for attending People's Law School. This year, People's Law School is brought to you by the Sinas Dramis Law Firm, Michigan Association for Justice, as well as our media sponsor, WLNS 6. This evening, our topic is about landlord tenant and foreclosure law with an emphasis on COVID-19 and how that has definitely made a lot of changes to this area of the law. I would like to give you a brief introduction. Next week, that will be Tuesday, November 3rd, we will not be having People's Law School that evening because we encourage all of you to go vote. The next session of People's Law School will be the following Tuesday. That's November 10th, and that will be on fire and explosion cases presented by attorney Steve Weston. My name is Jackie Dupler. I'm an associate attorney at the Sinas Dramis Law Firm based in Lansing. My practice area is primarily family law, that being divorce and custody. The format for this evening, we'll have a presentation for about an hour, and questions will be able to be asked throughout the evening through the chat feature in Zoom. If you are watching on Facebook Live, you can submit a comment to ask a question, and our tech guru will route that question to our presenter. During this evening, in case you're new to People's Law School, all of you attendees will be muted and your video will not be on. So just rest assured, you can do whatever you'd like during your chance to view. I'd like to introduce our speaker for this evening. We have Miss Karen Tjapkes. I knew I was going to mess it up. I'm so sorry, Karen. I practiced and I'm sorry. Karen earned her bachelor degree with honors from the James Madison College at Michigan State University, go Green, and her JD cum laude from Loyola University, Chicago School of Law. She is the Director of Litigation at Legal Aid of Western Michigan, based in Grand Rapids, where she is responsible for overseeing LAWM's advocacy and service delivery, establishing litigation goals and strategy, overseeing professional development of their staff, and grant management and compliance. Her practice is concentrated primarily on consumer and bankruptcy law, housing law, mortgage litigation, and an occasional public benefits case, as well as supervising the Homeownership Preservation Project and the West Michigan Low Income Taxpayer Clinic. She is also an expert advisor with the Center for Survivor Agency and Justice concerning consumer rights for domestic violence survivors. Ms. Tjapkes is the treasurer and sits on the steering council of the Grand Rapids Area Coalition to End Homelessness. She's obviously very busy and very involved. She is currently the secretary and past chair of the Consumer Law Section Council of the State Bar of Michigan and has been appointed to the State Bar of Michigan's Justice Initiative Task Force. She has presented on housing, bankruptcy, and mortgage lending issues for many audiences, including the Michigan Foreclosure Prevention Project, the Michigan Poverty Law Program, the Debtors Bar of West Michigan, the Michigan Conference on Affordable Housing, the National Consumer Law Center's Consumer Rights Litigation Conference, and as of this evening, she will be able to include the People's Law School via Zoom. So if all of you from afar could please give a warm welcome to our kind speaker, Karen, she will get started. Thank you.
All right, thank you. Let me go ahead and just get my screen up here. There we go. All right, so as Jackie mentioned, I'm Karen Tjapkes. I'm with Legal Aid of Western Michigan. I'm based in our Grand Rapids office. I'm going to be talking to y'all tonight about housing law, and specifically with a focus on how things have changed or paused or are somewhat different during our COVID-19 pandemic. So I'm going to talk primarily about issues related to landlord tenant law. Primarily because that's where most of the movement, most of the questions are at this point. But also I'll talk a little bit about land contracts and home ownership issues for those folks on the Zoom who might be interested in those issues. Just as a caveat, you know, us lawyers, we always have to put our caveats in. Nothing in this presentation is a substitute for a consultation with an attorney regarding your legal issue. So if you are here today because you've got something going on and you really need some legal advice or representation, while hopefully this information is useful, please do not take it as specific legal advice. You should go ahead and consult with an attorney of your choosing. So with that being said, we're going to start off with landlord tenant. A couple of things about landlord tenant. Landlord tenant law is essentially a contract. It's a lease. It's an agreement between the landlord and the tenant that the landlord's going to give the tenant a place to live, and the tenant's going to pay rent, and they're going to kind of do these things together. Now, in a lot of situations, the lease is written, and that's kind of nice because the lease can set out who's responsible for paying the water bill, who's responsible for sorts of different things. A lot of times written leases set out a very specific term. How long can the tenant depend on being able to live in that unit? However, there are oral leases or verbal leases where the landlord and the tenant just agree. Sometimes they text, sometimes they do it in person, sometimes they do it over the phone of a basic, what's the situation? I'm going to live there. I'm going to pay you $700 a month and we'll go on and do that thing. Now, it can be important down the road if you have a verbal lease to understand that if your lease does not guarantee you a specific time period to be there, then that might impact your rights should the landlord want his house back or his apartment back down the road. So just know that a written lease can always be useful in setting out the rights and responsibilities of everybody involved in a very specific way that avoids, or hopefully avoids, questions or misunderstandings down the road. One thing we always recommend is that tenants make sure they actually get the landlord's name and address and phone number, not just a random PO box, but they really understand where the landlord is. And you should do that right away before you get any money, because we have had situations where folks will Venmo money or send money to a random landlord thinking that they're putting a deposit on a house. And in fact, there is no house and the deposit money disappears. So it's good to do a little bit of due diligence. Make sure you know who you're working with and how you would get a hold of them. It's also good, again, to verify who owns the property that you're renting, that the person you're working with owns the property, or if they don't own the property, understanding how they have the legal authority to rent that property to you. Also, because again, I'm a lawyer and lawyers get involved when things go wrong, is one thing that's very important to do is to get things in writing. If you are paying your rent, get a receipt. If your landlord doesn't like to give receipts, pay with a check or in a way that can be easily verified should there be a dispute about payments down the road. If you give your landlord cash and your landlord doesn't give you a receipt, something might get miscounted down the road, and then it's going to be really hard to prove who did the miscounting. You should also get any agreements in writing, and this can be in an actual letter, it can be an email, it can be a text, although those can be a little hard to read should it go to court. There are things like if your landlord promised to fix something, get that in writing. Some folks, especially in this economy, are doing work for their landlords. They're painting, they're doing repairs for their landlord. And if your landlord says, yeah, if you paint this house for me, I'll knock something off your rent, it's important to pin down what that agreement is and then make sure that it is in writing, because if there's, again, a dispute in the future and the court can't figure out what happened, it may be very hard to enforce that agreement down the road. So it's very important to get these things in writing, to keep copies, should you need it, should there be an issue down the road. There is a very specific law in Michigan about the security deposits. Now, the first thing to understand is security deposits are different than fees. Michigan law allows like cleaning fees and those kind of things, and those are apart from a security deposit and non-refundable for the most part. The security deposit, on the other hand, is usually refundable if there's no damages or rent owing at the end of the tenancy. Michigan law does limit the security deposit to a month and a half of rent. So say your rent's $1,000 a month, your maximum security deposit would be $1,500. The landlord is supposed to provide the tenants with an inventory checklist at the beginning of their tenancy. And even if your landlord doesn't provide one for you, you should Google the form or make up your own form and go through and document what is and what is not wrong with the apartment you're renting. So if there's a big purple stain on the carpet, when you move in, make sure that that is documented on a form that you can give to your landlord, keeping a copy for yourself, so that day down the road, you're not blamed for the big purple stain on the carpet. When you move out of the property is kind of when there's this security deposit dance of who's going to do what when to try to get this security deposit, either let the landlord keep it or have the tenant get it refunded. Within 4 days of moving out, the tenant is supposed to provide a forwarding address to their landlord. It doesn't necessarily have to be where you move to. I know sometimes folks get a little, they don't want to always tell their landlord where they moved on, especially if they've had a a bad experience or something. But it can be a PO box, it can be mom's house, it can be some place that you will get your mail. Within 7 days, then within 30 days, the landlord then needs to provide the tenant with either the refund of the security deposit or with a list of the damages or reasons why they are keeping the security deposit. So that big purple stain on the carpet, whatever it costs to replace that, let's say. Within 7 days, the tenant then has the right to dispute the landlord's deposit statement. So say, again, the tenant says, didn't make the big purple stain, you can't blame me, you got to give me my money back. If the landlord still wants to keep the money, then at that point, the landlord is obligated to file a court case within 45 days. And if take it to court, prove to the judge if they have the right to keep the money. If the landlord declines to do this process, the tenant could bring their own lawsuit against the landlord to request their security deposit back. In fact, in some circumstances, if the landlord really messed it up and really didn't do what they were supposed to do, but the tenant did, the tenant could ask actually for double their deposit back as a penalty. So it's important to understand that process, whether you're the landlord trying to make sure you're reimbursed for damages correctly, or if you're the tenant trying to get your money back. Just a word about discrimination. There are laws, both at the state level and the federal level, that address housing discrimination, and that a landlord or a housing provider cannot legally discriminate against tenants based upon race, religion, color, national origin, age, gender, familial, or marital status, or disability. If you feel that you have been discriminated against on one of these bases, or if you're a landlord who wants to have more information about these laws, I would encourage you to Google your local fair housing center. There's fair housing centers throughout the state, lots of really good ones, Grand Rapids, Ann Arbor, Detroit, Kalamazoo, that can talk about that situation with you and whether there is an issue with discrimination. Repairs. This is often where things get difficult between landlords and tenants, is with the repair issues. So landlords and tenants have a duty to maintain the property and keep it in reasonable repairs. On the landlord side, that means the landlord has to keep their property up to code. They have to keep it fit for, human habitation and those kind of things. Now, if the tenant causes damage, the landlord can charge the tenant for those things. But if it's just wear and tear, if it's not the tenant's fault, if it's just, furnaces sometimes quit working and it's nobody's fault, it's just the furnace got old. For those kind of things, the landlord does bear the responsibility of the repairs. Now, on the flip of that, tenants also have a duty to keep the property safe and clean. So the tenants need to be taking out their trash. The tenant shouldn't be putting holes in the walls or doing things that would lead the property to become damaged. If the tenant thinks that a repair needs to be done, they should notify the landlord in writing about the problem and allow the landlord a reasonable period of time for the work to be done. Now, reasonable is going to depend on the circumstances, right? So if it's that there's a flood in the house because the toilet has developed some sort of problem, obviously that is something that the landlord needs to address faster than other things that, like a missing screen, which, is not an emergency and may not need something addressed right away. I also talk to tenants too about thinking through whether the repair request is really more about the health and safety of the property versus things that are more cosmetic. Because things that are health and safety, really, yes, those things you should talk to your landlord about and try to work on getting repaired. Things that are more cosmetic, like, a nice fresh coat of paint might be nice, but it's not making the house unsafe. Those kind of things are going to be difficult to get on a landlord about. And should there be a disagreement in the future, probably won't get you very far with a judge. If repairs are not done, we do recommend that you contact, especially if you're in a more urban area, any place, the township, the city that does building or code compliance, and have them inspect the property and see if they think there is a substantial safety concern, because they can use their power as the local governmental unit to try to get those repairs done. And again, if it should go to court, that sort of objective and expert opinion of the housing code folks at your local government unit is going to carry a lot of weight with the landlord, or excuse me, with the court, should there be a disagreement. There is lots of information on the internet and other websites about the concepts of repair and deduct, or withholding your rent for repairs. And what I would say is those are really tricky propositions. And the reason for it is that often these websites advise you to, not pay your rent. And if the court does not agree with you that what you did was right as a tenant, then you could very well have a kind of real financial jam down the road. So that it's often better if you have it available to you to work with the local governmental unit inspectors and kind of let them take the lead. If you do decide to do those repair and deduct or withholding rent type options, I would advise again that you really are very clear with your landlord, that you leave a really good written trail about your requests, that you've made lots of requests, that you've been very reasonable in your trying to communicate and get this done with the landlord, and that you were literally left with no other option. If you do decide to withhold the money, do not spend it on anything else. You'll have to have really good evidence at court, because that's where this is going to head, is to court. It should be known that landlords do have the duty and the right to inspect property. There's no Michigan law that sets out a specific a time period or warning period for a landlord to come into a property. There's sort of a generally accepted that 24 hours is sort of, an appropriate thing to do. Some leases will give a very specific time period for the landlord's notice. But again, in Michigan, there's no law that requires a set notice period, as there are in some other states and cities. I was gonna see if I can flip over to the chat box just for a moment and see if I'm missing any questions. Oh, where I go? Okay, now I can see the chat box. Nope. Okay, we're looking. I don't know if I'm just answering all the questions or if I'm just not to the good stuff yet that people really want to see.
Karen, from my perspective, I think that you're being very clear. So that might be it. Oh, it looks like we actually just got a question right now. Do you see it in the chat?
Yeah, the issue of first and last month's rent is sort of it's a little fuzzy. Isn't that a very unsatisfying answer? Is you have to talk with your landlord about what they think is going on there. Some landlords say first and last month's rent, and they really do mean that they intend to use that as last month's rent. It's not the commonest practice in Michigan. Michigan landlords tend to do the security deposit more. And so I would say, if you have a written lease, you probably should look at the written lease and what the written lease calls it. If it calls it a security deposit versus something else, it may not be a bad idea to then, especially if the lease is not clear, to email or text or somehow get a hold of the landlord and say, hey, this is what you said when we signed our lease or when I moved in. I just want to make sure I understand what you think is going to happen here so that I can plan, and see what they say. Rent increases are kind of common, especially, it's a weird time. It's such a weird economy right now. But I know going into the pandemic, a lot of our areas in the state of Michigan were having really, really tight rental markets. And so rent increases were very common. So I think that's definitely a situation where you need to sort of see what the landlord's expectations are, and see if they match with your own expectations, or again, see if there was anything in writing that would clarify that issue for you. All right. Let's go back to here. So obviously we're in a pandemic and that has changed a lot of things. So there we go. So there's been a few things that have happened since kind of I don't know if we call it the official start of the pandemic in March, but since certainly things kind of got shut down in Michigan. For several months from March until mid-July, there was a state eviction moratorium that was put in place by an executive order entered by Governor Whitmer. So that state eviction moratorium has since lifted. And now that we're at the end of October, I think that any issues or any kind of fallout from that we've probably processed. Different states have done different things with their moratoriums. And so what it may be applicable in like Pennsylvania or somewhere else is not going to be applicable to Michigan. So right now, Michigan does not have a state level moratorium. Courts are open, they're processing eviction cases. At the end of March, the federal Congress passed the CARES Act, which I think a lot of people have heard about. One of the provisions in the CARES Act did say that for certain kinds of landlord tenant situations, mostly when there was some sort of federal funding involved. So we had a tenant with a Section 8 voucher or a housing project that had some sort of federally related mortgage. They were not supposed to evict those folks during the CARES Act period, which expired at the end of July. So again, that protection for pretty much all those tenants has ceased. But if you're looking around online, or folks might, some of the landlords are still filing CARES Act affidavits to talk about whether the property is covered by the CARES Act. So if you see it, it's an interesting thing to know about, but it is sort of unlikely to give a tenant a protection from eviction. So then where we are left is the CDC, the Centers for Disease Control, put in a kind of opt-in moratorium for tenants. They did that beginning of September, I think. It's been a crazy couple of months. So the CDC, the Centers for Disease Control moratorium, that's based on their legal authority having to do with mitigating pandemics, stay at home, quarantine kind of things. Now it's an opt-in moratorium, so it only applies to tenants who invoke its coverage properly. And it does not apply to everybody in all circumstances. And so if you are a tenant that thinks that this might apply to you, or if you're a landlord who's trying to figure out if your tenants would be eligible to invoke this protection, and you're trying to plan properly, you really have to look at the language of what it requires. In order for a tenant to opt in, or for a tenant to invoke its coverage, they have to sign a declaration, which they then have to deliver to their landlord. And that declaration has a lot of things in it, but kind of the key things that a tenant needs to be able to attest to is that they've applied for governmental assistance to assist with their housing payments. And so in Michigan, the kind of two key funding or assistance programs that folks would need to apply for are the Department of Health and Human Services State Emergency Relief Program. And then also there is what's called EDP or Eviction Diversion Program funds available through a county agency that's sometimes referred to the HARA. And I'll talk more about how to do that and how to apply at your HARA in a moment. But you do have to apply for those things. You may not be eligible. There's different eligibility requirements. Some folks will be eligible, some folks won't, but you have to at least make the application so that the governmental agency can make that determination. Your income has to be below certain limits, but they're pretty high. It's like $99,000 for a household of one. So most folks who are renting, unless they're really wealthy like New York City folks, are probably going to be under those income levels just fine. Then the adult has to be able to say that they're unable to pay their rent due to a reduction in income, or that they have really substantial medical expenses. They're like about 7.5% of their income. So for most people, what's important for them is that they're unable to pay their rent due to a reduction or loss of income. Now, it doesn't necessarily have to be completely COVID related. It doesn't have to be that you got COVID, got fired, and now can't find a job. But it can be things like your hours were reduced because the business you worked at closed. You're a server at a restaurant, and with the reduced capacity, you're not able to get the hours that you were used to getting, especially with colder weather coming and not being able to do outdoor seating. So it's designed for those folks who have some sort of reduction in income or kind of a reason for why they're unable to pay their rent. The individual must claim or must show that they're going to make partial payments to the best of their ability. So if somebody is on, say they lost their job, but they're on unemployment, especially without the federal subsidy, the unemployment payments generally don't pay as much as their jobs, but it pays something. And so a tenant should try to make a partial payment based upon what their income is now, if at all possible. And then lastly, the tenant has to attest that if they are evicted, that they'll be homeless or they'll be inappropriately doubled up, and that is, inappropriate for the public health. There's a link here, which probably isn't going to come up great, but there's a website called michiganlegalhelp.org, which is pretty easy to remember. And michiganlegalhelp.org, one of the things they have on that website is a self-help kit that can walk a tenant through the CDC Eviction Moratorium. It has you answer a series of questions about, does this apply? Do you say yes? Do you say no? And if you walk through the toolkit and you answer all these things, the toolkit can help you produce the declaration, which you can then deliver to your landlord. We also tell folks that if you are involved in a court case, it's a good idea to send a copy to the court as well, so that the court can process that appropriately. Whoops, that wasn't the one I wanted to do. Well, since I'm over here, I will, yeah, I'll do this. So I did briefly mention there's these funding programs for the Eviction Diversion Program that can pay towards past due rent. It does require an agreement with the landlord for the landlord to forgive a little bit, but then it will pay in most cases about 90% of the past due balance. And so it's a really great resource. Those funds are going to expire or have to be returned to Washington at the end of the year. So if you are a tenant or a landlord who needs some help with paying rent, you should figure out this program. In each county, it's administered again by that HARA, the Housing Assessment and Resource Agency. So it's going to be a different group in every county. But if you look at michiganlegalhelp.org, They have a section on their website where you can search by county and you can find out who the HARA is for your county, as well as the legal services program for your county, so that you can get to the right agency and do that application. Each agency has they all use the same basic form, but each one has a slightly different way they collect it. Some of them will do it off a website. Some of them, need you to email it. Kind of, everyone's a little bit different. So it's useful to connect with the group in your county so that you can get that process started. The eviction process. The key point here is that the eviction process is court process. So that landlords should not be just putting people out on the street without a court process. The eviction process starts with a pre-court, what's called a demand for possession or notice to quit. The demand for possession usually says you owe rent, you have 7 days to pay the rent, or I'm going to take you to court. The notice to quit is for other types of problems with the tenancy. So that might be that you have a lease, but you've breached your lease in some way. Your lease says you're not allowed to have a dog, and you have a dog. So even though your lease says you should stay until January, your landlord will like you out now because you're not allowed to have the dog. For other leases that don't guarantee you a specific end date, either person, either the landlord or the tenant, can end that lease with a 30 days notice. And they don't need to have a reason usually to have that notice. So the landlord can just decide for whatever reason they're done. And without a lease that gives a specific time period, there's not a lot that the tenant will be able to say about that. The CDC declaration addresses primarily those cases involving non-payment of rent. There is a legal argument that it might apply to evictions that are just based upon the lease being up, but the courts are still deciding whether or not they agree with that position. So it's a little gray. But for the most part, if you get a termination notice, unless there's a reason why, or a lease provision that guarantees you a longer period of time, a lot of times the landlord's going to be able to get that property back. Currently, the procedure has an extra step in it that was required by the state Supreme Court because of the pandemic. So now there's a pretrial hearing where not a whole lot happens except the court tells the tenant about rights and about available assistance. If everybody appears for that first hearing, then they get to come back for a second hearing. And then at that point, if there's an agreement, they can do their agreement or they can decide how to proceed. If there's a dispute, then it would go to a trial. If the court makes a decision or if there's an agreement, that often ends up in a judgment. And then if the tenant doesn't comply with the terms of the judgment, they would get what we usually call the writ, which is the order of eviction. And that's what allows the court officer to put your stuff on the street. If the tenant does not show up at any of these hearings in the chain here, a default will get entered by the court. And that means that the judgment will get entered, the landlord's going to get pretty much whatever they asked for, and the tenant's going to be out of luck. So if you're a tenant, it's really important to show up at all of the hearings. And you can't just send somebody in your place. You can't send your girlfriend, you can't send your mom. You have to go there in person and represent yourself unless you've retained an attorney. All right, I'm gonna pause there for a moment and see where we are with questions. That's a good breaking point. I'm not seeing any in my box. I don't know if Nate, if you've got any on the Facebook feed.
Not so far.
All right. Yeah, there's a question, is this for residential? And a yes, I'm focusing primarily on residential. While parts of it are applicable to commercial property and businesses, especially the court process, a lot of the repair issue information, the CDC declaration information, those items are not going to be applicable to commercial leases, business leases. Then there's another question about the 2 types of assistance for the CDC declaration. We recommend that folks apply both for the EDP, which is through the HARA, but that you also apply for what's called state emergency relief. That's administered by the Department of Health and Human Services. So DHHS, those are the folks who do like food stamps and Medicaid. That's the same building. You can apply for that if you don't want to go in person. And I know in persons, a lot of things aren't in person right now. So you can apply for that online through your MyBridges account if you already have like Medicaid or food stamps or something set up with them. And we think it's the best thing to do both because you can actually get both depending on the situation. And it shows they have different eligibility requirements. So sometimes you'll be eligible for one, but not the other. And I think then you can really show the landlord or show the court that you are doing the best you can to apply for all available assistance. All right. Well, good. I will go back into this then. Just wanted to talk about a few issues about home ownership, veering away from landlord tenant a little bit. The first one I want to talk about is just a brief mention of land contracts. So land contracts are kind of this interesting situation where someone's usually buying a house, but instead of getting a traditional mortgage with a bank, they're usually paying the seller for it. Different states call these different things. In Michigan, we tend to call them land contracts, but some people call them contracts for deeds. They also sometimes, folks come in with leases with options to purchase, which might be more like a land contract, but might be more like a landlord tenant situation. So if you have something that's not quite clear in the paperwork, you definitely probably want to contact an attorney just so you understand what you really have and then what your legal rights and obligations are. But anyway, with a land contract, again, it's usually an agreement to buy a piece of property that the seller is taking the payments and the seller is kind of acting as the bank. So the purchaser pays the seller, and eventually at the end, if it all goes well, then the seller will give a deed to the purchaser. Again, usually folks go to lawyers when things go badly. And so when a land contract goes badly, payments aren't getting made, or there's been some sort of problem, a lot of times the seller will do what's called a forfeiture action. And it kind of looks and feels like an eviction action. You get a forfeiture notice before you go to court, kind of like a notice to quit or a demand for possession. And then if you don't pay the money or you don't do what's needed within that time period, then it goes to court, and it goes through that summary proceedings process like a landlord tenant eviction. So it feels very eviction-y. Although in the back end, if money is really the issue, you usually get a 90-day period, sometimes longer, to pay or get it all situated. They can also do a full foreclosure through the courts. It's a different procedure. It takes a lot longer, but it's also a lot more final, because at the end you don't just pay what you owe in terms of missed payments. You have to pay like the whole contract. So it's rare, but it is something that is out there. Mortgage foreclosures. So what is happening with mortgage foreclosures right now is that most of the mortgage foreclosure market is under a moratorium. So most folks, about 70% of people who own their homes, so residential mortgages, they have a mortgage that's either insured by FHA, VA, rural development, which is a USDA program, and so that's, again, more rural areas, or it's a loan that was made by or through Fannie Mae or Freddie Mac. Now, especially if you have Fannie Mae or Freddie Mac, you may not know what you have. And so if you have a mortgage through, say, Fifth Third Bank, very, very prevalent, at least in Grand Rapids, there's a really good chance that even though you're paying Fifth Third Bank and you think they're kind of in control, that actually that this loan is a Fannie Mae or Freddie Mac loan. So if you Google like Fannie Mae lookup or Freddie Mac lookup, you can find websites through Fannie Mae and Freddie Mac that you can put in your information and look up if you have a mortgage, if it's a Fannie Mae or Freddie Mac. Because you'll never know unless you really go looking for it or unless you go into foreclosure. But so those 5 kinds of mortgages are about 70% of the residential mortgage market, and they're all under a foreclosure moratorium until the end of the year. So that's why we're not seeing a lot of foreclosures, is that they can't foreclose. So unless there's a change in the law and a new moratorium is passed or something happens to extend this, we'll probably start to see foreclosures pick up in January. And again, these are residential mortgages. These are not commercial mortgages. Oh, hold on, I bounced ahead like really far. Or I goofed up my slides. So mortgage foreclosures, I think I goofed up my slides, I'm sorry. Here's my foreclosure slide. So what happens when you fall behind on a mortgage, that you miss your payments for some reason? There's a federal law that requires a mortgage servicer for most residential mortgages to do certain things. It requires them to try to reach out to you to see what's going on, to invite you to apply for what are called loss mitigation options, things that can help you get this mortgage back on track. And most of these mortgages have to wait for 4 missed payments or 4 months before they can move forward with foreclosure. So that gives the homeowner some time to try to right the ship, whether it's they've got access to money and they can get it caught up, whether they need to look at whether bankruptcy is an option, or whether they need to look at some sort of loan modification or selling the house. There is a link here, and I would also, you can Google this as well, is there are nonprofit state certified housing counselors who can help you figure out what is going on with your mortgage and help you work with your mortgage company to get that mortgage back on track, or to look at options to help you avoid foreclosure. These agencies are nonprofit agencies and they do not charge for their services, but these counselors are usually very well trained and know what they are doing. I've seen a lot of folks who end up paying a lot of money to businesses or to individuals who claim that they'll help them avoid foreclosure, but then the money disappears and the house is gone. So be very careful if you are choosing someone to help you with your mortgage. And again, understand and know that through the state of Michigan, through the Michigan State Housing Development Authority, or MSHDA, there is this network of certified nonprofit counselors who will not take money from you, but will do a good job for you. Okay? So under the federal law, for most residential mortgages, you got the 4 months if you live in the house to try to work it out. If you've used up your 4 months, or if you're a property that's not covered, it's not your primary home, or it's a commercial property, the state foreclosure procedure in Michigan is really fast. It's a non-judicial procedure, which means that there's no going to court. So if you're waiting for the chance to go tell the judge your story, it's not coming unless you file your own court case, okay? So one of the key takeaways there is don't wait for for someone to summon you to court. If you think there is a problem, if you think there's a reason why you shouldn't be foreclosed on, you're going to need to file that lawsuit as the homeowner. Because in Michigan, it only takes a couple weeks to do a foreclosure. They have to publish the advertisement of the foreclosure in a newspaper in the county for 4 weeks. And then they have to post a notice on the property one time within a couple weeks of that first published notice. And it doesn't have to be personally served. They don't have to come to your door and say, Mr. Jones, here's your foreclosure notice. All they have to do is smack it on the property somewhere. And that is sufficient for them to auction the property at the sale. After the auction, most properties get a redemption period. It's usually 6 months, but it can be more or it can be less depending on your circumstances. And during that redemption period, you can try to buy back your property or you can try to sell it to somebody else. But at that point, you have very few options. And if you get to the end of the redemption period and you're still there, they're going to be able to evict you. And at that point, it really is too late to really talk about what went wrong with that mortgage, especially if you think it wasn't your fault. Because at that point, your redemption period is over and all the court's really looking to do is evict you. So if you are looking at a foreclosure, reach out, see what the housing counselors can do to help you. Or if you think there's something legally going on that's not right, get to the lawyer or get someone who can help you sooner rather than later. Because again, if you get to that eviction point, you're not really going to be able to raise those issues very well at all. All right, I think I'll come back to that later. Yeah, I'll come back to these later because I'm going to do homeownership and then I'll come back to these questions at the end. All right. This is where I've discovered that my slides were out of order. So let me go back to this one. I want to talk just a moment about property taxes. Property taxes, for most homeowners who have a mortgage, your property taxes are escrowed, or a portion of your mortgage payment then goes into that special account and your mortgage company deals with paying your property taxes. But for other people, either their mortgage company is not doing that for some reason, or they own their house free and clear, and all they have to do is pay property taxes. So property taxes, as most folks know, you get a bill over the summer. In some places, you also get a bill in the winter. There is an occasional place that does a third bill, very rare, but occasionally it happens. If a homeowner is unable to pay those bills when they come due, it ends up in this sort of 3-year cycle. And the link there is a timeline of that 3-year cycle. But basically, if they get billed, if they were billed in 2018, so that's about 2 years ago now, and they weren't paid, then in March 1st of 2019, they're what's called forfeited to the county. So I live in the city of Grand Rapids. If I don't pay my taxes, then the city of Grand Rapids turns my tax bill over to Kent County as of March 1st this spring after they were due. Then the county tries to collect on them and they add fees and they add interest. And then if I still don't pay my property taxes, then they go into what's called foreclosure. And so the 2018 taxes are going into foreclosure for the spring of 2021. And at the end result is if it's your final last year to pay those taxes and you don't do it despite the foreclosure, you have until March 31st of that year to pay. And if you don't pay those property taxes by March 31st, then the county is going to own your property and you will lose your ownership interest. We are anticipating that because of COVID and because of all the economics surrounding that, that it is likely that folks are going to have trouble paying their property taxes. So I would encourage you to start thinking about what that plan looks like. A lot of the county treasurers are willing to look at doing payment plans and to look at doing things to try to give you some time to deal with those issues. There were some executive orders over the summer that sort of extended the timeline a bit, but most of those executive orders are up. And so unless the law changes, that is the deadline is going to be March 31st. Now, you should know that there are different exemptions for property taxes that you can apply for if you're eligible. So there is a principal residence exemption. If you use the property as your principal residence, you can apply for the principal residence exemption that lowers your property taxes. There's also an exemption for disabled military or disabled veterans, and you can apply for that if you're a disabled veteran. Then you can also apply for what's called a poverty exemption. If your income's below certain guidelines and your assets are below certain guidelines, you can apply for a poverty exemption, which would waive your property taxes for that year. You can't go backwards, but you can do it each year as long as you remain eligible. So, and again, while there is a court process for property tax foreclosures, it's not a really robust process. So I would encourage folks, if you've missed a tax bill, to get with your treasurers and see where things stand and make a plan so that you aren't left with a surprise in the spring. Okay. I think I've got a couple more in the chat here, or in my in my question and answer queue. The first one is, how much time usually passes from the time a tenant is given the initial document, all the hearings occur, and the final eviction is declared? It seems it would be a few months. And the answer is, it can be. If it's a non-payment case where it's a 7-day notice to start the process, those kind of go a little quicker because you only have to wait the 7 days. But if it's a lease termination that requires a 30-day notice, you are going to have to wait the 30 days. Then you're going to file at court. The courts are, what the backlogs looks like at the court really depends on where you live at this point. Some courts are pretty well caught up and can process evictions quickly. Other courts are still pretty backlogged, and it's taking a long time for them to get through the cases. But then, with a first hearing and then a week later, a second hearing, it can take a little while. Again, especially if you're in a court that's busier. So it could be a few months. It could be shorter, especially in non-pandemic times when the courts aren't backed up. The next question is about a commercial property, I think. So if a business has to close and it's not an essential business and they had to break a lease, can the landlord come after them for the months they were not on the location or the remainder of the lease, even if the landlord ended up renting the location 2 months after we vacate them? Most leases require, and most landlord tenant situations require, that if you break the lease, the landlord has to do what's called mitigate their damages. That the landlord has to do something to try not to lose as much money as they normally would. And so that does often involve advertising or re-renting the property. Now, while this is where it is important to read your lease, because your lease might have different clauses that talk about the what happens if the lease is broken and if there's penalties or if there's what are called liquidated damages clause. So the answer is, probably shouldn't be charging you for the whole lease if he ended up re-renting the location, but look at your lease, and it's probably worth a quick consultation with a lawyer to think all that through, since I can't give you that sort of individualized advice over the internet. All right. I think that's all the questions I see. And we have a few more minutes for questions. So I don't know if Jackie or Nate, if you are seeing other questions that I have missed.
I think that from what I can see on Zoom, it looks like you've answered all of the questions there. I don't have access to the Facebook Live, so I'm sure Nate is probably double checking that right now. But attendees, if you have any other questions, strike while the iron's hot. If you want to type that in, and we can hopefully see if it's something we can get answered to help you better understand the law.
Just while I've got you all, as you're typing your questions, 2 websites that I think are really good sources of information. The first, again, is the michiganlegalhelp.org. That has a lot of articles that are really useful, allows you, again, to draft a CDC declaration and walk you through the different parts of that. If you're involved in litigation, landlord tenant, family law, other things, it has a series of toolkits to help you understand the process and also produce your own court documents if you're having to represent yourself. The other website is, if you're looking for information on home ownership counseling or information on the eviction diversion funding, is www.michigan.gov/MSHDA, MSHDA, or you can just Google MSHDA and I think you'd probably find it. The question I have is, does the 3-year timeline reset if you pay partial taxes? And this is, again, I assume towards the property tax portion. If you make a payment, you have to make sure it gets applied to the year's taxes that you think you're paying. So if you mean to pay your 2018 taxes, you need to make sure you go to the county and pay the 2018 taxes and make sure they apply it there. If I were to go to the city of Grand Rapids, they don't have my 2018 taxes anymore. So any money I give them, they'd apply to my 2020 taxes, and that would be a problem. It doesn't really reset the timeline, I think, in the way you're asking, but if you pay off the 2018 taxes, then you wouldn't be in foreclosure, and then you could have a breathing space, and then you could figure out what you're going to do about your 2019 taxes. If you don't pay off the 2018 taxes in full by March 31st, and you haven't reached some other agreement with your county treasurer, the fact that you made a partial payment won't stop the foreclosure. You have to pay them off entirely or have reached an agreement about payment. I hope that answered that question. All right, I don't see any more questions.
It looks like that might be all of the questions right now, at least from what I can see. Guess real quick, Karen, is there anything else that you were dying to say this evening that you didn't get a chance to yet because you were whipping through it so fast?
I know I do talk fast. No, I think I kind of covered all the big things. I think my most important takeaway would be, don't wait. Legal problems never improve with time. So if you think that you're looking at a foreclosure or looking at an eviction, reach out as early as you can in the process, because we're often able to find better resolutions earlier than at the very end. So it can be tough to bring yourself to deal with these things, right? Because you're in a crisis, maybe you've been sick, you've lost a job, it's a pandemic, but really reach out sooner rather than later. And we can often be far more successful in your goals of keeping your home or preventing the eviction. Yeah.
Okay, and it looks like somebody just sent a chat question. It says on michiganlegalhelp.org, I see it differs or sends you to another site. It says lawhelp interactive.org, and they're asking if you know about that site.
Yeah, I know Michigan Legal Help is built on a platform or on a model that's used by some other legal services programs in some other states. And I think that must be kind of the technology behind it in terms of the walking through the different forms generators. If ultimately your question is this a website that I can trust? It is. I know the folks here in Michigan who maintain the content on it. And I trust them that they're up to date on the law. So, and I've never heard of a complaint in terms of privacy issues or that they retain information on the website in a way that would compromise privacy. So I think that there are email addresses off that website. If you have a really specific tech question or concerns about privacy, I would reach out to the developers of the Michigan Legal Help website and see if they can answer those for you.
Okay, I think that might be all of our questions. Karen, thank you so much for being here. Thank you so much for our attendees participating, via Zoom, but also through their questions. I think it's really nice to feel that feedback. I think 2020 has kind of made us feel like we're a little bit alone. So thank you so much. And hopefully everybody will be busy next week on Tuesday, November 3rd, voting or, encouraging others to vote. And then the following week, we hope to see as many of you back as possible for fire and explosion cases. Have a good couple of weeks. Thank you guys all so much.
Thank you.
Thank you.